The Supreme Court has yet to rule on President Trump's birthright citizenship order and on his bid to remove Federal Reserve Governor Lisa Cook as the court's term comes to an end. As the United States Supreme Court reaches the final opinion days of its 2025 to 26 term, two of its most closely watched cases remain undecided as of June 29, 2026. In the case known as Trump versus Barbara, the justices are weighing President Trump's January 2025 executive order that would deny automatic United States citizenship to children born on American soil to parents who are in the country illegally or on temporary visas. In a separate case, Trump versus Cook, they are deciding whether the president may remove Federal Reserve Governor Lisa Cook, whom Trump moved to fire in August 2025 over allegations that she misstated which home was her primary residence on mortgage applications, claims that Cook denies. Legal observers expect both rulings during the term's final opinion days, by early July at the latest. Start with what every side concedes. On his first day in office in January 2025, Trump signed an executive order directing federal agencies not to recognize citizenship for children born in the United States to parents in the country illegally or on temporary visas. The 14th Amendment states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. The Supreme Court last directly addressed that citizenship clause in the case of Wong Kim Ark, decided in 1898, long read to grant citizenship to nearly all children born on American soil, regardless of their parents' status. On the Federal Reserve side, in August 2025, Trump moved to remove Governor Lisa Cook, alleging she had designated two properties as her primary residence on loans. Cook denies any wrongdoing. The Federal Reserve Act allows removal of a governor only for cause, a term the statute does not define. Lower courts, including United States District Judge Gia Cobb in September 2025, blocked Cook's removal while the litigation proceeds. Oral arguments were held January 21, 2026 in the Cook case and April 1, 2026 in the Birthright case, and neither had been decided as of late June. At the Cook argument, nearly all of the justices, including several conservatives, voiced doubts about the president's claimed power to fire Federal Reserve Board members at will, though Justice Thomas appeared more sympathetic to the administration. Underneath the legal briefs sit pressures that do not fully reconcile. The administration is pressing to expand presidential authority over who counts as a citizen at birth and over agencies long shielded from at-will removal, testing precedents like Humphrey's executor. Against that stands the credibility of the central bank, which markets and the Fed's own inflation fighting depend on keeping insulated from short-term political pressure, whatever the legal merits of Cook's case. And there is more than a century of settled expectation. States, hospitals, and families have operated on automatic birthright citizenship, and any change forces large administrative and human adjustments. Each side is also working the narrative. The administration and its allies want listeners to see Trump as restoring the original meaning of the Constitution. Opponents want listeners to see existential stakes, statelessness, and a politicized Federal Reserve. The court and specialist legal outlets push a narrower frame, that this turns on the meaning of specific words and the result is not yet known. Here is how each side sees it in its own strongest terms. The Trump administration argues, on citizenship, that the 14th Amendment's phrase, subject to the jurisdiction thereof, was adopted to secure citizenship for freed slaves, not for children of those temporarily or unlawfully present, and that more than a century of practice rests on a misreading. On the Federal Reserve, it argues a president must be able to remove principal officers, and that documented misstatements on Cook's mortgage applications supply lawful cause. Its incentive is to deliver a signature immigration promise and to assert broad executive control over the administrative state. A win would reshape immigration and expand presidential removal power, while a loss would cap a core second-term initiative and reaffirm limits on the presidency. The challengers, immigrant families, states, and the ACLU, argue the amendment's text is plain, was reaffirmed in Wong Kim Ark, and codified in the 1952 Immigration and Nationality Act, and was deliberately placed out of reach of any government official. Stripping it, they say, would render thousands of children born on American soil stateless. Their incentive is to preserve a long-settled constitutional guarantee and prevent a two-tier system of citizenship at birth. An adverse ruling would directly affect children of undocumented or temporary visa parents and the states that issue documents and benefits. Lisa Cook and defenders of Federal Reserve independence argue that removal without genuine for-cause grounds would let a president purge the central bank over policy disagreements, threatening economic stability and market confidence. Former Treasury secretaries and economists warn that politicized central banks chase short-run gains at long-run cost. Cook's incentive is to keep monetary policy insulated from White House pressure and to defend her own position and reputation. The ruling will set whether and how a president can remove Federal Reserve governors, with potential effects on interest rate credibility and markets. The justices, for their part, frame their task as interpreting constitutional and statutory text, the meaning of subject to the jurisdiction and of for cause, rather than ruling on policy. At argument, Chief Justice Roberts told the government that even in a new world, there is the same Constitution. The court's incentive is to resolve the disputes on legal grounds while guarding its own institutional legitimacy, and its rulings will define the limits of presidential power over citizenship and independent agencies for years. Finally, a note on how the coverage itself splits. On the American right, outlets like Fox News and the Washington Examiner emphasize a textual reading of the amendment and frame the case as Trump restoring the clause's original meaning, at times casting current practice as a careless misreading. Center-left outlets like CNN and NPR lead instead with the stakes, threats to Federal Reserve independence and to millions of children born on American soil, and with the justices' skepticism of Trump. And non-Western outlets like Al Jazeera and the South China Morning Post cover the cases from an outside observer stance, as a test of United States constitutional limits on presidential power, often centering affected immigrant families. No opinion has issued. The result and the court's reasoning are not yet known. Want the whole story, every side with the sources? It's all at pressureoftruth.com.